Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Calum Cheyne. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. We jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Calum Cheyne and Luke Zadkovich. How are you, Calum?
Very good. How are you doing, Luke?
Good. Off the back of a lot of travel this week. Good to catch up with you in person, and had our annual partners retreat. So that was a bit of fun.
Yeah, great seeing you and all the gang. And we got Jakob on the podcast today, and an old colleague, old friend, and now flying high at Quadrant and finding his name on the top of exciting Admiralty cases.
Yeah, it's good to be back. I've actually come into the London office to use your kit and also use it as an excuse to say hello to everyone. So it's nice to be back here and see everyone. Good to see you. Good to catch up.
Yeah, and who have you found in the office today?
Well, Miguel, fresh back from paternity leave, so that's very exciting. And I've met the new office dog, Isla. Big, yeah, I'm sure.
All the stars in that case.
Big names, exactly. Well, for those who don't know, Jakob Reckhenrich, he's at Quadrant Chambers. He's a barrister there. Dare I ask, how long has it been now, Jakob? I suspect it's much longer than I suspect.
Yeah, it's shockingly coming up for a year. So I think I left the firm in March last year.
Okay.
Wow. Yeah, I know.
Time flies, huh? Time flies. I suspect it's been a busy time at your end as well, hey?
Oh yeah, very busy. Good stuff. Had a couple of big hearings, mostly arbitration, so nothing you can talk about. But it's really exciting to have this judgment come out in the Admiralty court, where I was led by Show Carrier KC, and we were successful. So that was really exciting. And it's good to get your name on those judgments and be able to talk about them and have the law develop a bit too, which is really fun.
And I was going to say successful seemingly across the board on this one.
Oh yeah.
Which is always nice when you're in that position.
Yeah. 3 grounds, won on all of them. I'm sure we'll get onto that, but yeah, that's really nice.
Yeah. And maybe just so when I say that you're a former colleague, I think that's probably strictly not quite true. You worked with us for a long period on a kind of secondment basis. But one thing that we're trying to do a bit more with guests when they come on is talk through kind of different pathways into law and different, how people got into different roles. And yours is quite an interesting story through to Quadrant, and it's nice that we feature in it, albeit briefly.
And it's been great. I was here for a long time, and very happy memories.
Yeah. And then moved on, as you say, last year to Quadrant. How have you found the change between being in a firm for a couple of years with us, or slightly less than a couple of years, and then moving back into Chambers?
Yeah, I think it's incredibly useful having had that experience, and I think it's something that a lot of my junior colleagues don't have. Some people do secondments, but they tend to be at most for a couple of months. But really, having been a part of the team in that way, I think just gave me a completely different sense of what actually happens day to day, and not just what happens on a particular case, but how you balance the pressures of different cases and how you deal with that sort of thing. And ongoing relationships with clients is something you just don't see in the same way in Chambers. And when I was here, I went out to Geneva a couple of times and saw people with partners and that sort of thing. And that's just, you just don't get to do that in Chambers. It's all very nice. You sit around, you sort of have a bit of a think, and you read the papers that are nicely presented. And I like that, and that's why I do that. But I think it's really healthy to see what it's like on the other side. And it's really fun too. So I think barristers sometimes forget sort of the fun side of that too. So I think that's been really helpful in, building relationships with new people too. And, I think they can tell like, oh, you sort of, how it works, which is different.
I've seen it from the other side.
Yeah, it must be good to, see how it works on the client relationship side and how that kind of informs the whole process, because, for those listening in who are perhaps from the US or other jurisdictions that don't have a split bar, in England, we have this kind of division, if you like, between solicitors and barristers. The barristers being the ones who stand up with the wigs in court and handle mostly the advocacy, and the solicitors who are more client-facing and prepare the cases for hearing and kind of handle that part of the process. Now, there's overlaps. Calum and I are both solicitor advocates and do our own advocacy on certain cases as well. And the barristers kind of have done a lot of the advisory work early on, these days more than perhaps they may have decades ago. So, the lines blur a little bit, and it was great to have you with us for those couple of years, Jacob. And I've got some fond memories of the cases that we did together and some of the hearings that we handled in-house.
And indeed, we're still on a few cases together, Jacob, that we were on.
Yeah.
Oh yeah, it was plenty of stuff keeping us busy. So it's nice to catch up in a slightly different fashion, not just over how's this case going. But
exactly.
Yeah. I had one question. Quadrant Chambers is obviously known for its shipping work and commodities work and other kind of sector-focused cases. Have you only been doing that type of work, or have you had some other different types of cases come in? How's your kind of spread of work look for the first year?
It's a good balance. I think I think most things I do have something to do broadly with the shipping and energy sector, and that's what I like, and that's the reason why I wanted to go to a set like Quadrant. There are other people who have much more sort of pure banking or pure fraud kind of practices, and I think I'm happy to do that work too, and I enjoy doing it. But I think I do really like the shipping and commodity stuff, and that's why I'm at Quadrant ultimately.
Yeah. Well, we've got a case to talk about today.
Yeah.
That has a bit of shipping. I'm right in understanding that you were on the right side of this one.
Yep. Happily, Cockrell was with us on this one, so that's always good. I was her judicial assistant briefly, so it's nice to see her in court from this side now.
Yeah, I saw that on your profile. I had a quick squeeze before jumping on and saw that reference. So for those that don't know, this is a case that is from the High Court of England and Wales. It was handed down in January 2025, so pretty recent case. As Jacob says, before Mrs. Justice Cockrell, DBE, and the parties are, I'll just skip through this quickly because there's quite a lot of parties involved. We've got RTE as a claimant, second applicant, Costain and Network Rail as the defendant, first applicant, and importantly, Stema Shipping UK, which is the third party respondent, Stema UK, and there's another Stema party involved, and also split chartering as well, and a bunch of others that don't really feature in this particular judgment. It is one of those cases that's got a lot going on in the fact pattern. I think actually some of the legal principles can be distilled quite concisely. So do bear with us. And we're talking about today limitation claims in a maritime context, where for those that haven't come across these, it's got a quirky type of claim where a party can limit their liability for a maritime incident. And there are some guardrails on which parties can limit and the nature of those claims that can be limited. And this is not just a UK type of action. You can bring these limitation actions elsewhere in other jurisdictions as well, but we're dealing with the UK today. And then the legal point kind of that we're going to unpack relates to res judicata and other principles that go to when a party has run a claim through the system, a decision's been decided, and whether they can recast that claim or bring a claim that wasn't technically in the first set of proceedings. As I say, we'll get into that in some detail, I'm sure, but it touches on things like issue estoppel, the Henderson principle, and a few other points. Jacob, maybe you're probably the best man here to go through some of the facts here and lay it out if you don't mind.
Absolutely. And I think just before I do that, I wanted to add one point on limitation, because I do think it's an interesting point. And for people who haven't dealt a lot with limitation, it can seem a bit puzzling because, as you say, Luke, the idea is if you've got a ship and your ship runs into, say, a bridge, then you can limit how much you're liable for. And that's something that's really unusual. That's something we don't really get in a different context. So I think initially, I often find when I tell people about this sort of thing, they really struggle getting their head around why is that a thing we have. So I think it's worth just pausing on that for a moment. And there's a fun line from a good friend, Lord Denning, in a case called the Bramley Moor, where he says, I agree that there's not much room for justice in this rule, but limitation of liability is not a matter of justice. It's a rule of public policy, which has its origin in history and its justification in convenience. And if you read the cases that go into the policy justification, basically, as you'll know, the idea is that we have it to encourage shipping. The idea is that the people who came up with these principles said, look, if people who run ships were exposed to unlimited liability, they just wouldn't do it. And we care enough about global commerce that's the kind of thing we'll put in place. Now, query whether that's true, but that is the stated policy of the law. And I think sort of once you understand that that's what underlies it, it's a bit easier to understand how these decision works and why things happen the way they happen. And I think another key feature about it is that limitation is a function of how big your ship is. So the bigger the ship, the bigger your liability. So if you're a small ship and you cause a lot of damage, your limit is still very low. So it's just a question. The bigger the ship, the more you have to pay.
Yeah, it's a good point to emphasize. I saw that was referenced in the judgment as well. I think what also has happened over time is that there's a whole insurance regime that's built out around limitation claims. And we could talk for a long time about the P&I insurance and other types of shipping insurance in H&M and what have you. But there needs to be some limits, or arguably there needs to be some limits on these types of claims so that insurance can be arranged. Now, you could have a debate about, well, where should the insurance be getting put in place for this type of thing, for unlimited liabilities like this? We see it in other types of very large casualty claims as well. But I just thought to mention, it's, once there's a system that's devised to try and put some limits on the quantum of these claims, there's then an insurance scheme that's kind of built on top of that then develops over time in assessing the risks and what have you.
Yeah, no, I think that's a very important point. I agree with that. Right. Well, shall I get on to sort of bringing us closer to the facts of this case? So France and the UK, as you can imagine, both have big electricity grids, and sensibly they're connected. Now, as you'll have realized, France and the UK aren't connected by land, so you've got to run some cables under the sea. And there are a number of those, and a pair of those cables get to the UK by Kent. And so that's the starting point. There's some cables coming ashore on the Kentish coast, and they connect the French and the UK power grid. Then in 2016, which is when things happen, we've got this barge. It's an unpowered barge, so what's called a dumb barge. So it doesn't move by itself. You get a tug or something to move it around. You've got this unpowered barge hanging out off the Kentish coast. And the reason is because it's bringing some rock from Norway, which is going to be used to rebuild a wall that was damaged near a railway line off the coast. So you've got this barge there. It's anchored. And the problem is that it was a dark and stormy night, and the anchor drags across these power cables, and so they break. And you might wonder, look, well, what's this barge doing over there being anchored near some power cables? And that's a very good question. And the answer to that's slightly awkward, because the person who drew up the box where they thought it would be sensible for this barge to be anchored used a sea chart from 1980. Now, in 1980, those power cables weren't there, but if they had used a contemporary chart, those cables, as they always are in charts, are drawn in, and you would have realized that this might not have been a great spot to anchor your boat. So that's sort of...
Isn't it amazing that, like, what seems like such a fundamental mistake can lead to, what are we at? Almost 10 years of litigation now.
Yeah.
Millions in claims and what have you. I think there's 3 or 4 sets of proceedings going on in different countries, or because someone used an out-of-date chart.
Yeah, it's pretty wild. But these things happen.
The out-of-date chart, or the chart which is used, it doesn't. There's some new some new feature somewhere in the maritime landscape, and the old chart's wrong. The new chart would have had all the information that the master needed to avoid it. And before you know it, you're into litigation.
Yeah. So that's the factual background, right? So that's what kicked everything off. And then that's how we get into limitation. So we've got these 3 companies that are all related in one way or another to the boat. So we've got Stema UK, we've got Split, and we've got a Danish entity called Stema AS. And we're not going to talk much about 2 of the 3 of them, because one of them owns the barge and the other's the charterer of the barge. And the way the limitation convention works is there's no doubt about them being entitled to limit, right? That's just how it works. Sort of the person who can limit is the owner, and then owners defined in various ways, where that includes the charterer. So no question about it. No one disputed that. But there's this interesting entity, Stema UK. Now, who are they? Well, they are a UK-based entity, unlike the other 2. And because the barge doesn't have its own crew, because it's not powered, it gets dropped off by a little tug. And then you've got some people to do some stuff, to, for instance, drop the anchor and, sort of deal with the rocks and that sort of thing. So you've got some employees of Stema UK shuttling out and sort of handling the barge and doing the local things, and they arrange for the rocks to come from the barge to the shore. So what they said initially is, look, we're the operator of the barge, and therefore we're entitled to limit. So the reason that's relevant is because in the limitation convention, which I've handily brought with me, it says the people who are entitled to limit are the ship owners or the salvors, and then it says that the term ship owner shall mean the owner, charterer, manager, and operator of a ship. So they say, look, we were closely involved with this barge. We're doing all sorts of stuff on board it. So we fall in this definition of operator. That was their case, right? And that's arguable. And they argued it in front of Mr. Justice Tier, who said, yeah, that sounds good to me. And then RTE wasn't best pleased with that. So they appealed it, and they went to the Court of Appeal. I wasn't involved in that stage, so I wasn't there for that, but I read it all in detail. And the Court of Appeal said, tell you what, I think to be an operator under the convention, you've got to do a bit more than just popping a few people onto the boat. What you have to do is you have to have sort of responsibility for the operation of the boat at a slightly more general level. It's not enough to just have some people physically operating some machinery on the boat. You need to be sort of responsible for maybe economically running the ship or that kind of thing. So they took a look at the convention and said, nah, that's not good enough. So that was stage 1, right? And I think that's independently a really interesting case. I don't know if you covered that on the podcast. I don't think it came up at the time, but that's sort of an independently interesting decision on limitation and what you get as a finding. And well, what does it mean to be the operator of a ship? And got some good guidance now. What you have to do is you have to be more generally involved in the running of the ship. It's not enough just to, pull a few levers here and there.
What do we think about that? So yeah, I saw the comment here. We haven't looked at that case previously on the pod from memory. Maybe it's a good one to do at some stage, Calum. But what do we think of that? That to be an operator, you need to have some higher form of management and control of the barge.
Gut instinct, it makes sense to me. When you talk about a ship operator in the market, you'd be talking about someone who is a who is more of an operator than an agent, I suppose.
Yeah, you've got guys like V-Ships,
Right.
those big entities, and they run the whole the SMS, and they do all of the controls, and sort of lots of stuff, not just we put a few guys on board for a minute.
Just to check though, was Stema UK related to another Stema party that was involved that was able to limit its liability?
Yeah, so all three entities are part of the same group, so they're all closely related. Exactly.
But it's a curious outcome in a way, where you could have a corporate division between entities where one, presumably the other entity did more of the commercial management stuff, did it? Or
Yeah,
not really.
So we've got the owners who, from memory, didn't do a lot of managing, and then we've got the charterers and the people at the chartering entity. They do a lot of the sort of day-to-day management. They decide what business she takes and so on, and they would organize the tug and all of that stuff.
I suppose what I'm saying is, if a related affiliate, a Stema party, say a parent or even just an affiliate, kind of side by side, had taken on more of the management side of it, and another affiliate, say Stema UK, had taken on kind of a lower role, if you like, more operational, on the ground, practical role. It is a curious outcome that, because that group had kind of made a division between who was going to do what in terms of operating, that one falls into the scheme and the other doesn't.
Absolutely. And I think sort of from a litigation strategy point of view, it's an interesting position, because in the position of RTE, so the owners of the cable, what you want to find is someone who's closely enough involved so that they can be liable, but not so closely involved that they can limit.
Yeah, you're right. Yeah,
really interesting.
I think also if you look at the limitation convention, when you're talking about who is an operator, it forms part of this Article 1(2), where it says the term ship owner shall mean the owner, charterer, manager, and operator of a seagoing ship. I think, again, if you read that in context, the operator, when it's talking about the owner of a ship or the charterer of a ship or the manager of a ship, and then you throw operator in there, kind of with the owner, charterer, and manager, then I think the nature of operations would be something slightly more, as you say, Jacob, than just putting a few people on a ship. The owner, charterer, and manager will have real kind of day-to-day large oversight involvement in what the ship is doing, and the operator in that context presumably is operating it in a similar way.
Yeah, exactly.
I suppose what I'm driving at is really highlighting what Article 1(4) does, in that if you have someone who is kind of sub, like an agent, or someone for which you're responsible for, so you have like parent subsidiary between Stema AS and Stema UK, and you couldn't really say that Stema UK is an operator because they don't have the management dimension, then that pulls in 1(4), and 1(4) would be the scenario where you kind of catch that party and pull it within the kind of the parent, so that both can actually limit, and you don't have this kind of lacuna.
Which is more natural for
what they're trying, right? So I think that's a great segue, because sort of not having worked on operator, they've then sort of had a regroup and say, well, okay, maybe we're not the operator, but Stema AS and or Split, who can limit, are responsible for our actions, and therefore we should be able to limit. So just to sort of get the basis for that, as Luke says, that's Article 1(4), which says if there's a claim in respect of which someone can limit, and that person is responsible for the actions of someone else, then that other person can also benefit from limitation. Now, what this usually, I think, is taken to apply to sort of the crew. Like, that's the master and the crew. They can limit under 1(4) because the owners are responsible for their actions, but they are obviously not the owner of the ship. I think it's also fairly clear that subcontractors can't. That seems to be generally the view. And so the question is, well, what about this Stema UK entity? But the problem is that we say that they took this argument too late, and that's sort of where we really get into this judgment, right? So,
So we're not looking at that question in this judgment. We're looking at whether or not that question can be asked.
Precisely that. That's exactly right. Because, what happened is you've got the incident, we've talked about that, 2016 anchor dragging. Then you go through this whole process where you go to Mr. Justice Tier. He says, yes, you are the operator. Then you go to the Court of Appeal and they say, no, you aren't. And then a few years later, they say, hey, we've got this other idea. And we say, hold up, that's not how it works, right? And that's where we get into the sort of res judicata and Henderson stuff. So I think that sort of takes us to the judgment. But that's important to understand. You're absolutely right, Calum. We're not talking about would they be entitled to limit under Article 1.4. We're talking about can they make that argument now?
Yeah.
Ultimately, it's a question.
Exactly. And there's a few points to kind of unpack in that as well, in that just on a factual basis, it wasn't that Article 1.4 wasn't mentioned at all in the first set of proceedings. It did come up marginally and then was dropped in the Court of Appeal and abandoned in oral argument. So, it's not like it was a complete afterthought. It was in there somewhere. It wasn't properly argued, obviously. And, they've kind of wanted another shot at it. But if you were sitting down, like I think one of the reasons my mind went to the conceptual element of this, I know it's not what we're going to talk in detail about today, but when assessing, and this is kind of more of a practitioner's point, and not looking for your comment on it, Jacob, in a way, given you're involved in the matter, but it does strike me that there's an element there to which, in the initial claim for limitation, the Article 1.4 point really needed to have been put more clearly and forcefully from the outset. All eggs were kind of on the operator argument without kind of having the alternative point there. And then even though it was raised at the Court of Appeal, it was then dropped. Yeah, I'm not sure why that was done, but it didn't really play out that well at the end of the day. There was some more procedural kind of detail in that process as well. But ultimately, you're right. We're now kind of, it's a second bite of the cherry where Stema UK is wanting to limit on the basis of Article 1.4 when there's been a very clear decision by the Court of Appeal. Permission to appeal to the Supreme Court was not granted, so it was the Court of Appeal decision that held. And it says very clearly, we can read out the language here, that Stema UK is not entitled to limit. They want to now come and say in the follow-on substantive proceedings that they are able to limit on the basis of Article 1.4. And RTE, your clients in this case, Jacob, is saying, well, hang on, you should have done that already. You could have and should have done it already.
Exactly, yeah. And that's the language of one of our grounds, the could have and should have. That's the Henderson and Henderson. And we can talk about that in a minute. But sort of we had three arguments that we said, look, three grounds why you shouldn't do that. And the first one is, which I think is sort of a neat point, is that there's an order and it says so. And, you might think, like, okay, well, what's there to that? There's an order and it says what it says. But there's interesting case law in it that says that regardless of what was argued before in the hearing where the order was made, if the order is clear, it does what it does. And I think just to sort of give you a flavor of how strong a principle that is, one of the cases we relied on is a Privy Council decision in a case called Winston Gibson and Public Service Commission. That's a 2011 position and decision. So there's this guy, Mr. Winston. He's a civil servant in Trinidad and Tobago. He's out of the country while some new promotion scheme for some important position is announced. So when he comes back, it turns out he's missed the window to apply, which is unfortunate because he's interested in the role. And then he goes to court and he gets a declaration from the court that says he's eligible for this position. Now, that's a decision that was wrong in law. It shouldn't have been made. It's clear that he wasn't eligible, but it's not appealed, right? So he's got this declaration. It says he's eligible. It's wrong, but no one appeals it. Then he applies for the job, and lo and behold, he doesn't get it because they say, you're not eligible. And then he goes to court again, and he seeks review of that decision. So he says, well, look, I got this declaration earlier. It says I'm eligible, so you can't go around saying now, but you're not eligible. And so it goes to the High Court, and then it goes to the Court of Appeal, and they both say, well, look here, if we interpret this order in just the right way, really what it means is you should be considered in the light of the criteria. But of course, the criteria say he's not eligible. And then he takes it to the Privy Council, and the Privy Council says, yeah, that's all very clever what you did there in the Court of Appeal and in the first instance, and we totally understand why you want to do that. But that's just not how it works, right? The order says you're eligible, and that's what it means. So that's really interesting. So the Privy Council is crystal clear on this, and there's some other cases that Cockrell cites where orders get made that shouldn't have been made, but they're not appealed. And that's it. Sort of, if the order is clear, you can't just say, oh, look, but here's something that was argued or that wasn't argued, so that's not what the order should mean. That's the end of the matter. So that was our first point. And there's this lovely line in the judgment where she says about our argument, although the argument is one which at first blush has an unattractive formalism about it, I conclude that RT is quite right about this.
Yeah, that's a nice thing to read.
I had the same thought. Calum, have you ever come across this issue before, that an order is what it says, and you can't go behind the language of the order unless it's ambiguous? And it makes sense that if you've got a problem with an order, appeal it.
Exactly. You have the chance to appeal it. And I think that one of the interesting things about this case is normally when you're looking at issue estoppel or Henderson, you're looking almost at things that are slightly more complex and difficult than this. Whereas your first argument is very neat in that, it may be whatever it was, overly formalistic or unattractive in its formulism, but it is a pretty simple argument. This has been there is an order on this point, and the order is final, and it's too late. And I can, I think we then get into maybe the more fiddly legal arguments, particularly around Henderson. And that's a much more delicate analysis of could you and should you have raised this point sooner. Whereas this is simply saying the court has made a decision on this point, whether you like it or not, and it's not going to make another one.
Yeah, exactly. It goes back to what I was saying before, though, and really puts a spotlight on the decision not to insist on Article 1.4 being heard in the Court of Appeal, and for all the difficulties in getting in new arguments at appellant level and all the rest of it. It's a better position to be in than this one, where you end up with an order against you, and you're stuck with the terms of that order having not appealed.
And this was just, I think it sort of bears repeating, because you're saying the issue here really was that the order was drafted broadly to encompass there wasn't a specific order on 1.4. There was a broad order on the applicability of the limitation. But the order was kind of broad enough and clear enough to have the effect of meaning that 1.4 is knocked out by it. But it wasn't like the parties have argued this point and I've made a decision on the specific arguments under 1.4. It was more, I've made a broad, this is a broad order that touches on anything that could be argued under the or in terms of the limitation claim. And I suspect that was kind of the argument against it, or the argument against a finding that this has already been ordered was, well, this is a kind of specific point, whereas what's been ordered before is a more general one.
Yeah, exactly.
It was also interesting that the court in this decision, well, I don't know if criticize is too high, but basically took issue with the lack of authorities that Stema UK kind of put forward in response to RTE's arguments. They pointed to the Sanssouci decision, the 2012 decision against VRL Services. But other than that, they didn't really have much to say. Maybe that's because there's not much to say on the point. But it was almost like it read, at least in this decision, that that wasn't ventilated all that much, or much issue was taken with it on the Stema UK side. Almost like it was too contrite a point, and it wasn't really argued that in detail. I don't know. I'm kind of reading into things here in the decision. Maybe that's unfair, but that's how it read in this section anyway.
No, absolutely. And I think that's certainly how it felt at the hearing. We were running these different arguments, and obviously Stema had lots to say about some of them, and it just didn't have that much to say about this point.
Mm-hmm.
And we were a bit, all right.
Yeah.
But in part, there isn't that much to say. The principle is really clear. The only argument you can realistically have is about whether the order is clear or whether it's ambiguous. So it's true that the judgment says, oh, they don't engage so much with the authorities. And, you know, perhaps that's a little unfair because maybe there just isn't that much to engage with. The principle is fairly clear. And I think you can't really defeat it on a clever reading of the authorities, but really only on construction. And as Cockrell says, the order is crystal clear. So that's sort of game over.
So the other point, well, that's really the end of the game right there. RT prevails, but the court did helpfully go on to consider the other points that you ran, which were contingent points, in effect, having ruled in this direction on the primary issue. So I was looking at the estoppel, cause of action estoppel, and then, well, it didn't have to deal with issue estoppel, but primarily looking at cause of action estoppel. I found that an interesting section.
Yeah, I think sort of while it's very satisfying to win on a short point, I think as a lawyer's lawyer, I think that's the most interesting section because I think that's really something that develops the law a bit. I think the first section applies the law in a straightforward way, and that's nice for us because it's good to win. But if you can win and also develop the law a bit further, that's even more fun, and that's what's going on in this section. Shall we talk about the argument a bit then? So cause of action estoppel, it's a relatively well-known principle. It's if a cause of action has been determined to exist or not exist, you can't argue that point again. That's sort of, that's the basic idea that we all know and like. So we said, look, here's a cause of action. It's limitation under the convention, and it's already been determined. That's the end of the matter. And there are a couple of interesting and fiddly points about that. So I think let's sort of just talk about them individually and see what we think about them. So a good point to start on is, well, is it a cause of action? So you've read the judgment. What would you make of her discussion of saying, yes, it is a cause of action?
I think most practitioners in the market would see it as a cause of action. I think that's how it's often advanced as almost a claim in its own right, although it does have this kind of defensive effect.
A limitation claim we're talking about.
Yeah.
I think so. Yeah, I think so too. Yeah, I can see how, we opened at the outset that it's an unusual type of claim. It's not one that you see all the time, but nonetheless, given the substantive effect that it has, it does seem to me to be substantive is probably the wrong word. The significant effect that it has, I think it is a cause of action. I suppose the gloss on it is that it has been described as a procedural kind of defense in some ways, and so substantive is the wrong word because it kind of is a bit of a misnomer. But it is more procedural in its nature, yet the consequences, if you like, are quite significant.
Yeah, absolutely. I think it's a really interesting point. I found this probably the most interesting point when we were getting ready for the hearing to think about it. Because it's true, as we said at the outset, and as you've just said, Luke, it's an unusual thing. It's sort of this standalone thing, but it doesn't affect the underlying substantive cause of action. It just affects on how much a party can get paid if they succeed. So you can, it's definitely, it looks a bit different from some other things. So you can see why someone might say, oh, well, maybe it's not a normal cause of action. And there's this case law, there's particularly Caltex, that was probably the most helpful decision for Stema, where the judge sort of had a fairly detailed analysis, and they said, look, I don't think this is sort of proper law. I think this is procedural law. But it's really important to understand the background to that decision, because the question he there had to determine was, am I applying English law where this case is being heard, or am I applying some foreign law, which is where the casualty took place?
Yeah.
And if you decide that it's procedural for these purposes, then you apply the domestic provision. And he said, look, there'd be all of these terrible consequences if you had to not apply just the law of the forum, because if you have sort of a container ship with lots of different contracts of carriage that may be governed by different law, it'd be crazy if you had to apply all sorts of different enactments of the Limitation Convention at the same time. So you can see that there was pretty big pressure to find a way of finding you apply the English style. Mm-hmm. And the way to do it in that case was to say it's a procedural thing. And there's enough in how these claims work to say that, to make that credible. But I think, that just doesn't carry over to other situations. And there are all of these other cases which Cockrell relied on, and where judges say it's its own cause of action. And in that case, what they cared about was whether proceedings in one country where the liability action was tried involved the same cause of action or a different cause of action from the limitation action. And as we know, it's quite common that you have the liability action in one country and you've got the limitation action in another country.
Yeah.
So in that context, it makes sense to say it's a substantive cause of action. And so that sort of sets up the dichotomy. And I completely agree with you. I really do think this is a substantive cause of action, because ultimately what you have is you go to trial, you've got witness statements, you've got findings of fact, you've got the whole thing, and at the end you've got a judgment. It just doesn't feel right to call that sort of a merely procedural thing.
No, and the way that it's advanced as well, this is discussed in the judgment, but you can advance your kind of limitation claim. Even the nomenclature suggests that it's a cause of action, because people refer to these as limitation claims. You can advance it proactively, and you can say, I'm going to bring this limitation claim of itself to establish the right to limitation, or you can bring it as a defense to the claims brought against you. But in either case, it smells like a cause of action, and it kind of looks like a cause of action in the way that it's presented, rather than saying this is some kind of procedural issue that we're going to raise as part of these proceedings.
Yeah, exactly. So that's but I think that's interesting. So, because I think that's one of the things that judgment is now authority for, and which is a point that there just wasn't clear authority on before, that for the purposes of res judicata, cause of action, estoppel kind of arguments, limitation is a cause of action. And that's a development, and that's really helpful to know. That's something we now sort of have in our arsenal of points to be able to rely on.
I was thinking, though, that your point, Calum, about being able to bring a limitation claim before the substantive claims, it is an interesting one in a way, and perhaps that helps color the argument, because if a limitation, call it a defense, could only be brought as a defense, and could only be brought in a defensive posture. So, if a substantive claim is brought against you and you want to cap what your liability is at, and it could only be brought as a defense, then I don't know, maybe it is more of a procedural kind of device, or a defense rather than a cause of action. But the fact that it can be brought at the front end before anything else, as a claim, it is an interesting argument. And I know I raise that not to compare it with limitation claims in the US, but I know that in the US it's much harder to bring front end claims for declaratory relief. Like in England, we're quite comfortable with that. actually bringing a claim for a declaration that we don't owe someone something, or there's no liability here. Whereas in the US, that's not as common, and actually, in a number of instances, you need to wait for a claim to be brought against you before you can then advance the defence to that. So it's a really interesting point, Jacob. I think there's a lot in it, actually, and if you start comparing it with some other jurisdictions, in a general sense, I'm not comparing it to limitation claims in the US because you can bring them on the front end too, but it's not. It is something that is more common in the UK that you can actually advance defences in a front end way by way of declaration.
That's really interesting. So I think that probably leads nicely into the other point that I thought was really interesting about what she found on the cause of action estoppel argument, because another key element of estoppel usually is that you have to have been a party to the proceedings to be able to rely on it. Because the cause of action estoppel is, if Calum sues me and then the judge finds something against me, I can't argue it again after Calum. But if Luke sues me later, I'm free to argue that again because it's different parties. I'm not estopped. There's nothing binding between Luke and me. And what's interesting is, so we were one of the applicants, but Network Rail and Costain, who were the other applicants, they hadn't actually been a named party to the original limitation proceedings. So we were, but they weren't. So in ordinary proceeding, that would mean they wouldn't be able to benefit from cause of action estoppel because they weren't a party to the proceedings. And so that gets us to this other point that's really interesting. We've said this a couple of times now. Limitation decree is general. So you go to court, you say, look, here was this casualty, and I think these three guys might sue me. But, just in case anyone else is going to sue me, I also want to limit against them. So you name the parties who you think are going to be likely to the liability action, but then you say, and against anyone else. And if you succeed, then you get a decree that's binding on the world. So, and then Cockrell looked at that and said, well, if that's the case, then that must mean that the normal rules about who can benefit from cause of action estoppel don't apply. Because if the whole world is bound, if the owners succeed, that must mean if they don't succeed, even the people who weren't a party to those proceedings must benefit. So I think that's the second thing that hadn't previously been clearly stated in the law that she makes clear. And I think that's absolutely right. I think that has to be right. But it's really good. It's really interesting to see that play out.
It is interesting. So if you succeed, then you succeed against everybody, and no one else can come along and say, actually, that was wrong. We want another crack at challenging the limitation action.
Yeah.
And therefore, if you don't succeed, then you don't get another crack at it against anybody else who brings the claim.
Exactly that. It's a kind of equivalence thing. You can't win against everyone, but then try again against some other people later. That just doesn't seem right.
I suppose that has to be the case, because otherwise you would have, if you take the example of a claim that you and I have, and then there's a claim on a similar point with you and Luke, it's very unlikely that the decision in the later in time case of you and Luke is going to have any bearing on the kind of sanctity of the decision reached in the claim against you and I. But if you have a limitation action in claim A, and the ship owner fails to establish the limitation, and then in claim B you have a second bite of the cherry for the ship owner to establish the limitation, and they do establish it, then you'd have this issue where they go back to claim A and say, well, hang on a minute, we've got to everything.
Yeah, but these principles that we're talking about here, what do they go to? They go to establishing certainty of process, certainty of law, so that parties can't have multiple bites of the cherry. They go to questions of court resources, and that if there's a proceeding on foot deciding certain issues, that if you've got an interest in that, get involved, have your say, and then live with the decision. And there are other kind of convenience factors in there as well, but that's what we're talking about here, and that's where the court needs to have some limit on these things. Otherwise, claims will just keep coming back around like a yo-yo, which I think comes on to the last section of this judgment, which we probably can deal with relatively quickly given the time, and that's the Henderson and Henderson type argument. Do you want to just touch on that briefly, Jacob?
Absolutely, yeah. So Henderson, well-established principle, which says if there's an argument you could and should have run earlier, you probably aren't allowed to do it later. So technically, it's sort of a three-part test: is could you have done it, should you have done it, and then sort of in all the circumstances, would it be oppressive to do it now? But really, sort of it comes down to could you and should you have done it? And we said, look, you clearly could and should have run this argument in front of Mr. Justice Tier. Now, sort of, why was it raised so late? Well, probably there's when Lady Justice Rose gave permission to appeal to the Court of Appeal, she mentions this argument. This is the first time the Article 1.4 argument pops up, and they then try to argue it in the Court of Appeal, but there just isn't the evidential basis there. But that doesn't mean they couldn't have argued it in front of Mr. Justice Tier had they set out to do it. And, we spent a lot of time at the hearing discussing about how practical would it have been to do that, how factually complicated would it have been. And of course, it would have been a slightly more complicated inquiry, but you could have done it. And I think sort of just to round this out, one point that's a useful takeaway is that the ALDI guidelines were mentioned in this judgment. So there's this case where the court made clear that if you have some point that you think you want to take at a later stage, that's something you need to tell the court about. You can't just keep that to yourself and then run it later. If you don't mention it at a case management stage, then it's pretty likely that you won't be allowed to run it later. And that's something we relied on. We said, look, if they wanted to run this, if it's really true that it would have been incredibly complicated to run those arguments all at the same time, which is what they said, then the least they should have done in front of Mr. Justice Tiers, they should have said, here's this other argument, Article 1.4. We want to run it, but we think now is not the right time, but we're telling you about it. And then the court would have been in a position to say, well, let's look at the court resources and how we should use them. And they could have said, actually, you have to run it now, or that's it. Or they could have said, absolutely, that's fine. You can do it later. So the practitioner point to take away from that is probably if you're ever faced with the kind of situation where you think, well, there's this other point I could make, but it's a bit tricky and maybe it would involve a lot more evidence, or there are other reasons why it doesn't seem like now is the right time. Don't keep that to yourself. You've got to bring that to court and you've got to say, I want to reserve this point for later. And if you don't do that, then things are going to be really difficult for you later down the line.
Yeah, I completely agree. What about at the appellant level? And of course, I'm aware of the difficulties in introducing new points at appellant level. I think, Calum, you'll recall a case that we had on the podcast where we looked at the difficulties in bringing in new arguments that rest on facts that weren't dealt with at trial at appellant level. But as to the point about reservation, maybe is a way of putting it, what was there a way of carving out the Article 1.4 argument at appellant level before the Court of Appeals such that there wasn't such a clear, broad order issued ultimately at Court of Appeal? Or is that, it was too late, but the horse had bolted by that time as well?
Well, I think so. I think that could have helped with the first argument. So Stema could have tried to get the wording of the order to be such that it only said isn't entitled to limit on the basis of Article 1.2. Right. That's something, and query whether, that would have been agreed by the judge, but that's something they could have tried. And if they had succeeded with that, that would have helped with our formalistic point. Yep. But it wouldn't help you with Henderson and Henderson. And if you So I read the transcript of the Court of Appeal hearing before we went into this hearing, and there was discussion about that actually. And there's sort of, Stema's counsel said, well, I want to run this later. And the Court of Appeal basically said, well, we can't give you any comfort on that.
All right. Okay.
Sort of basically they said the Henderson argument will play out how it will play out. There's nothing we can say about that now.
Fine.
Interesting. Yeah.
Yes.
So, the horse had already bolted
I
at that
think
stage as well. Yeah.
Yeah, I think that's right. At that stage, it was too late.
That makes sense to me. I would have thought that's right. But, I was curious.
It does show how careful you have to be, at least in the build. I think in the build up to a high court hearing, you have a bit of margin to play for to try and introduce new arguments. But
yeah,
it sounds as though once you're through that first hearing, it's difficult to sort of bring this back in. One question I had on the interested for your take on this, Jacob, on the cause of action estoppel and the issue estoppel points. Given that you succeeded on this kind of simple point on the Court of Appeal order already dealing with this question, do you think that those comments then become obiter, and the helpful new law that's generated by this case is actually reduced to being an obiter comment rather than a kind of ratio of the decision on the issue estoppel?
So I think strictly speaking, that's true of one of the 2 points.
Right.
So true of the proposition that a limitation claim is a cause of action. So I think that's right. That's strictly obiter. The fact that any party is bound is actually a comment she makes the first time when discussing the order.
Okay.
So she says that also applies to other parties,
Right.
even though they weren't a party to those proceedings. So I think that and because the point itself is general, so I think we can say that that's clearly not an obiter point. But it's reasoned in detail. We argued it. So it'd be surprising if someone didn't follow that. But yes, I think that's right. So I think one of the 2 points, strictly speaking, is obiter and the other one isn't.
Fascinating. Look, thank you so much for your time, Jacob, and for sharing your insights on this case. Well done on the result. And thank you, everyone, for listening in. We hope you've enjoyed the conversation today. And I know I have. When I first opened this case and I'm looking at res judicata and issue stuff, I'm like, oh, okay, well, where's this one going to go today? But there's actually a lot of interesting points in here. What about you, Calum? What do you make of it?
Great catching up with Jacob, first and foremost. Big congratulations on a very successful result, winning on all of the different heads. Great to see your name on these kind of case notes. It's cool, having someone who worked with for a couple of years, seeing them go on and do this stuff is it's really nice to see. So it's great having you on. Thank you for giving up the time and for talking us through it. Really enjoyed the conversation. But yeah, mainly just congratulations on the result, and it's awesome seeing it all going so well for you.
Great. Well, thank you so much for having me. It was really nice to be back, and it's nice to be able to talk about this. And the
real pleasure.
the auto light now meeting room clearly lasts for 1 hour. It's just gone off there for Jacob.
Real pleasure again. I think I spoke over that.
I think
well, at least you know how to turn the light back on in the conference room, Jacob. You've done not the first time.
Absolutely.
Awesome, good stuff. See ya.
Cheers, everybody.
Take care.